Today is April 10, 2024. My name is Rob Carr of Kalamazoo Right to Life. This is Pro-Life Week. Well, this has been a very busy and active and explosive week regarding abortion-related topics and issues. So it would be a full program today. Last week, the Florida Supreme Court ruled that the state's 6-week fetal heartbeat law will take effect on May 1st. Oh, this is great news. Florida, Ron DeSantis, governor, strong pro-life majorities in their legislature. They're moving in the right direction. They had passed a 15-week limit about a year and a half ago, and then they passed a 6-week heartbeat bill. It was challenged, and the courts have now said it takes effect on May 1st. And this is just great news. Florida, I believe, is the third most populous state in the country. So many, many lives will be saved in Florida because of this ruling by the state Supreme Court. Okay. Over the weekend, Donald Trump was asked if he supported a federal, national 15-week abortion ban. Oh, I hate to use the word ban because it conjures up this image that you're taking away somebody's freedom. It's a ban. You're stopping me from doing something that I want to do. And I would rather use the word limitation, like a 15-week limit on abortion, rather than say ban. But he was asked about this 15-week legislation, and he says he did not support it. And he deflected back to the Supreme Court with the Dobbs decision of 2 years ago, in which the court ruled that abortion policies will be governed by the state legislature, or through like the will of the people. And that could be in the form of state referendums. So in either case, the people vote for their legislators, and the people would vote on referendums. But either way, the voters, the citizens of individual states, would make the determination whether or not they want abortion legal or limited or outlawed. So you've got liberal states that have retained abortion rights, and you've got conservative states that have banned abortion. And in some cases, all the way back to the moment of conception. So lives are being saved in many conservative red states. So Trump has gotten some pushback by his answer. Some pro-lifers are upset. Pro-abortion people are upset. I think it's an evolving issue that will perhaps play itself out as we get closer to the November election. So I'll just leave it at that. The big story happened yesterday on April 9, when it's a huge story, when the New York Times calls it a political earthquake. It's the Arizona State Supreme Court ruled that the state's 1864 anti-abortion law will take effect again. It is now going to be enforceable. And this is amazing news. Obviously the pro-abortion people are all upset. 1864, women couldn't even vote. How dare you take away women's rights? This is an old law. Well, I'm going to give you two examples of old documents, American documents, that we abide by today, and no one questions them. And the first one is a very obscure document from 1787 that we abide by faithfully. And this obscure document is called the Constitution of the United States, drafted in 1787 and ratified in 1789. It is the document that our government is based on. Separation of powers. It's what we abide by as the document that we live, that we uphold, we stand by, we live by. The U.S. Constitution, 240 years old, but It's a lot older than the Arizona law from 1864. Second document, 1803, U.S. Supreme Court case called Marbury versus Madison. And in this case, the Supreme Court, for the first time, ruled that the court had the authority and the power to review laws enacted by Congress to determine whether or not these laws were constitutional. And Marbury versus Madison is one of the 3 or 4 most influential and it's a landmark ruling. It just is. Hugely influential case. The whole issue of judicial review is based on Marbury versus Madison 220 years ago. So here again, liberal, conservative, everybody abides and applauds the fact that the courts can tell a rogue legislative law, no, you've overstepped your bounds. That law is not constitutional. We applaud that decision. Okay, so now going back to the Arizona law from 1864. It banned abortions through all 9 months of pregnancy, except for the physical life of the mother. Rape and incest was not included as exceptions. And there is a few things. I kind of want to go back into a little bit of history about abortion, because I think there's a lot of misconceptions or ambiguities about some of the issues. U.S. abortion law was basically based on, adhered to British common law. It was pro-life for centuries. But there were problems, and the first problem was that legally, whether it's in the U.S. or in England or continental Europe, legally, the law did not state that a woman was pregnant until quickening, where the baby, the first time the mother could feel the baby kick in her womb. And when she quickened, then the law said, okay, ma'am, you're pregnant. If you have an abortion, we can now punish the person who performed that procedure. We can punish that person. So obviously she was pregnant the previous 4.5 months, but legally the court said it's at quickening. So a woman theoretically could have obtained an illegal abortion prior to quickening, and the courts would not have prosecuted her, because the courts would have said, well, legally she wasn't pregnant. So now it sounds kind of crazy, but medical science was pretty ignorant about a lot of things regarding fetal development and issues related to reproduction. They just were. So the other problem Connecticut became the first state in 1821 to pass a pro-life or an anti-abortion law, and then New York followed a few years later, and a lot of states, Michigan 1846, a lot of states passed pro-life laws before the Civil War. But the problem is that most of those laws said that the victim of the abortion was the woman, the mother, and it didn't really talk about the baby, who is the true victim of an abortion. So in 1857, the American Medical Association, the AMA, they were a fairly new group. Their doctors began noticing problems with the rise of illegal abortions and complications from them. So they established a committee to review the issue of illegal abortions and come up with recommendations. And the person who chaired this committee was this man. He was a doctor, Harvard-educated, Horatio Storer. And in 1859, he issued his report that basically said that the true victim of an abortion is not the mother. The victim is the baby. And they also said that the baby is a human being from the moment of conception. And medical science was changing in the maybe 2 decades before the Civil War. And they concluded from a lot of these new discoveries that the quickening benchmark was no longer defensible. So when the AMA issued these recommendations, they were one of their main recommendations was, we want to go back to these state legislatures and have them revise their laws and make them more pro-life, more restrictive, because the victim is the baby. The victim is the unborn baby, who is a human being. And states from between 1860 and 1880, almost every state in the country revised their laws and make them much more pro-life. And most of these states had banned abortions through all 9 months of pregnancy. And even in places like U.S. territories, like Arizona, they passed their law during the Civil War, 1864, very pro-life law, but it was done on the basis of this man's organization that he was the leader of called the Physicians' Crusade Against Abortion. The Physicians' Crusade. The doctors looked at the new evidence, the science of fetal development, and they concluded that the baby in the womb was a human being from conception. And they pressured state legislatures to enact newer, tougher laws to outlaw abortion. And that's where things basically stood until the mid to late 1960s, when states began to change their laws and reform or legalize abortion in certain cases. And then when Roe came along, they opened the floodgates wide open. Okay, but going back now to Arizona, Arizona's law is now on the books, and the other side is just screaming mad, so much so that the Arizona State Attorney General has said that she is not going to enforce this law. She's not going to do it. Well, I beg your pardon. Going back to the U.S. Constitution, we have laws, and we have to follow these laws. I mean, back in 1973, when Roe v. Wade was decided, only 19 states actually had pro-abortion laws. The other states were all pro-life. But the Supreme Court's ruling forced the pro-life states to abide by Roe. In every state in the country, we know this, every state had abortion clinics. We could not enforce our previous pro-life law because the Supreme Court said you can't. Well, here in Arizona, the law of the state is the Supreme Court of their state. And they say the law of 1864 is now back on the books. It's enforceable again. Abortion is outlawed in Arizona except for the physical life of the mother. And this Attorney General says, no, we're not going to enforce it. Well, I see a constitutional challenge here, and I don't think she has the right, legally, constitutionally, the right to disregard a decision by the state Supreme Court. So we'll see how that plays out in the next week or so. But this is a great decision. Now, there may be some collateral damage, because I know when Roe was overturned, there was some backlash and we lost some referendums. So I don't know how this is going to play out, but I'm going to close now. Babies will be saved because of this Supreme Court decision, saving babies' lives. And that's what matters most. With that, I'll let you go, and I'll see you next time.